Welcome back. Now we take up the question of what is customary international law. Remember, this is the source of the law. The restatement says it's the highest source of international law. Well, in general, customary international law is that body of commonly accepted rules of conduct. The rules that have arisen from consistent and long-standing practice around the world, that there are rules that have been created over the centuries, and that if these rules are accepted as the law, then they should constitute a source of the law. Nations follow these rules out of a sense of binding obligation, knowing that if they violated these rules, then they will have violated the law. Not simply broken a contract, but actually violated international law. So nations follow these rules even though they may not be written down somewhere, even though there may not be an enforcement mechanism. People follow these rules out of the sense of binding obligation. They have to follow these rules because it's the right thing to do. Now, there are two elements to customary international law. When we talk about customary international law, there are two elements that must be present. And the first of that refers to a general practice. It must be the general practice of nations. Now, the problem is we don't know what constitutes a general practice. How many countries have to follow this rule in order for it to be considered a broad enough rule to rise to the level of customary international law? And what about those countries that don't follow this rule? Will they be bound by custom even though it may not be their particular custom? But in general, we look to see, is the practice widespread? Is it consistent? Do countries follow this rule over time without controversy? And the second aspect of customary international law is it must be accepted as the law. We follow this rule not out of a sense of morality or out of a sense of, well, it's best for us at this point in time to follow this rule, but countries accept this as the law. They accept this rule as the rule. So a general practice that is accepted as law. Those are the two elements to customary international law. Now, there's a case in your book on this, and I've got some references online as well to allow you further discussion. And the case is generally known as the Paquet Habana. Now, this case arose out of the events of the Spanish-American War in the late 1800s, involving the conflict between the United States and Spain that was based in Cuba. Now, in the law, the rules of war traditionally said that when two countries were at war, that one country could take the commercial vessels of the other country, meaning the freedom of the seas was suspended if two countries were in conflict. And so if there was a cargo ship belonging to Spain, then in fact the United States could take that cargo ship, could seize it, even though it's a non-combatant, and take the goods and sell them and then divide the results from the sale. It was traditional in the world's navies for centuries that a portion of the sale would go to the government, but then a portion of the sale would also go to the captain and the officers and the crew of the ship. This was called prize money. And so the Paquet Habana case really revolved around this notion of prize money. Now, what makes it unique is that the Paquet Habana, the ship that was taken by the United States, by naval vessels of the United States, was not a cargo ship, but was a fishing vessel. And in fact, the people on board the fishing vessel were not aware that the countries were at war, And in fact, they had left the dock to go off on a fishing expedition prior to the war having occurred. And so they were completely caught unawares by this U.S. naval vessel that seizes them. And the U.S. naval vessel treats this fishing boat as a prize, meaning they take it and another fishing boat that was also captured, and they take it back to Florida and they sell it, and then they divide the money up. Well, the owners of the Paquette Habana, the Spanish owners of the Paquette Habana, objected to this seizure. And so they filed a lawsuit to get their money back, to get the value of the boat back. And so what the court was faced with the question of, was this seizure of the Paquette Habana, was that valid under international law? Now, at this time, international law was held to be that custom, general practice accepted as law. And so in analyzing whether or not the Paquette Habana could be taken as a prize, or whether it was exempt from the category of being a prize, the court looked at, well, what is the practice in the world? And what they discovered was they looked at 8 different countries, and that in fact, in most of these countries, fishing vessels were off limits to warring parties. The idea being that a fishing vessel is out plying its trade, it has nothing to do with material. All it's going to do is bring back food to the country to feed people that need to be fed. And so traditionally, fishing vessels were hands-off. You couldn't take a fishing vessel. And so the court said that this custom meant that the United States ships had violated international law in the seizure of the vessels from Cuba. So it was a general practice accepted as law. You can't touch fishing vessels. And so they awarded the money that was earned from the sale of the boats to the original owners. Now, there was another thing that came out of the Paquette Habana case that you should know, and that's the idea of why is it that international law is applying? Because the defendants in the Paquette Habana, the people who had gained the money from the sale of the ships, they objected to the use of international law. They said, even if this custom is international practice, it's not United States practice. It's not United States law. You know, you can look in the books. There's no law that says I can't take a fishing vessel. So there was the argument that international law cannot apply in a domestic court. But the Paquette Habana court addressed this matter as well, and they said that international law is binding domestic law. And so this international law is the same as if it had been enacted by Congress and signed by the president. It is binding domestic law as well as binding international law. So those are 2 very important holdings out of the Paquette Habana case, and you should know those for your exam and your writing assignment.